Okay, I will call this meeting of the Ethics Commission to order. It is 9:02 a.m. Are there any agenda additions?
Art, I request that we have an additional agenda item about inviting the governor to a commission meeting.
Okay, let's see where we can put that. Let's put that as 11 and a half. Is that okay?
Yes.
Okay
Okay.
with me.
Any other agenda additions?
Ward,
Hearing
I
none?
have,
Yes, go ahead.
I'm asking that the commission just table discussion on item number 7, discussion of process for investigating relevant information until we can get some additional information to the commission before we have that discussion. So I'm just requesting that.
Okay. So can we take it off the agenda then?
Yes.
Okay. We'll do that. Any other changes? Hearing none, we'll go to the executive director's report.
All right. Happy Wednesday, everybody. We'll go ahead and get started. I just want to note, I have a note for you guys in the meeting minutes as well, that usually you guys are adopting the minutes from the previous meetings, but with having only a temporary part-time operations administrator who's helping us out on a very limited basis just to bridge the gap until we bring on somebody new, those meeting minutes have not been a priority. And as soon as we bring somebody on full-time, which will happen here soon, those will get caught up. So you guys will have probably in August a number of meeting minutes to approve. But just wanted to let you know that we have not prioritized that. So as far as the budget update is concerned, it is early in the month as well. The June cycle ends, or we start getting bills for the most part up until July 10th, but there was some delays in IT data processing this month. So I do believe that this is up to date as it is, but I want to let the commission know that there may be changes to the June 2025 budget as final expenditures for the biennium come in. So this is our last month of the biennium. After today, Alicia and I will work on closing packages for the 2023-2025 biennium on the commission's budget. You will see what our total expenditures for the biennium were. You can see our June expenditures. The expenditure total for June was $53,850.67, bringing our biennium total to a little over $1,100,000, or just shy, excuse me, of $1,131,000. You will see that we have a remaining budget. Alicia did a really nice job of combining some of our charts there of just shy of $35,000. So if we go down to expenditures outstanding, at the bottom of that, we have our ending balance for June. So you will see that we have an ending balance for our expenditures of really about $6,677. This is really from our salaries and operating lines. This is what we will be turning back. The additional expenditures that we have that we won't be using come from our professional fees, meaning when we hire outside counsel or outside investigators. We had done an estimate back during the 2021 legislative session as to what that would be. And 2023, I wasn't around in 2021. 2023 legislative session, and it was about $121,000. And we ended up having roughly $28,000 left in professional fees. And that seems maybe like a bit or a little bit, but if we look at how much we projected and the data that we had to reach that projection, we were within roughly 10 to 15%. So I think that that was a fairly good estimate in hindsight based on the limited data that we did have. So we will be turning back roughly 34,000. I think that there's a travel voucher or two that still needs to get approved. So it might end up being just shy of $34,000 that we'll end up turning back. And of that 34,000 or 35,000, 28,000 of it relates to professional services. The rest of the budget we came in, I would say, as close to the nail as we can get with 6,000. Any questions, concerns, comments about the budget?
Did a good job.
I definitely miss having Alicia to give you guys the update on the budget.
Yeah.
But Alicia has continued to work on our budget and make sure that that stays up to date. And she'll be helping with closing packages. And then we have some other things that we need to take care of with OMB. I talked to her on Sunday about helping us with those, just based on time distribution of employees. So moving on to Ward, am I good to move on?
Yes, please do.
All right, so then we have our filing update. We usually provide the commission with much more detailed information, but with limited operations administrator time, we have not focused on collecting. I mean, we are collecting this data, but tabulating this data. This is still done in a non-automated fashion, so this does take time to do. So we have not done this for June. We will catch you guys up in August once we have somebody back on staff. But as far as we can give you some information, and that is that in June, the commission closed 9 complaints, and the commission currently has 55 pending complaints. So we have gotten that down a little bit. 55 complaints is still quite a bit that needs to be managed, and that will lead into my discussion on our HR update later on. Any questions on filing update, etc.?
Okay, move on.
Hearing and seeing none, I'll move on to, usually it feels like every month we are reviewing a policy and procedure for the commission. We are reviewing a policy later on when we talk about settlement guidelines, but I did just want to briefly do an overview of the current policies and procedures and really wanted to get information or feedback from the commission if there's something that they want added, revised, changed, etc. A few of these we have adopted more recently or that have been amended more recently, but some of them also are just really required for auditing purposes or for OMB to be in compliance with OMB policies. So just to review very quickly, I'm not going to walk through every single one of these, but the commissioner pay policy, this is pursuant to statute. Commissioners are paid on a daily rate that's provided. In statute, there's actually 2 statutes that are in play. We have broke that up into a full day and a half day, and when that happens, if the commission remembers, we revisited how we were applying this policy back in, oh no, I'm blanking on when we did that. It was recently within the last few months, and that we changed the how we were applying this, even though we didn't change the policy. I do want to let the commission know we have been paying commissioners in accordance with this policy as discussed at the previous meeting, and that when a commissioner attends a meeting that has been requested either by the chair or myself, they are paid for that time. based upon the policy outlined. The other one that we've utilized lately is this media relations policy, that typically the executive director is the individual that is assigned to speak on behalf of the commission. However, there is an option or an opportunity that the executive director has a designee. Usually that's done in conjunction with the chair, if that happens. There are instances that I have asked Logan respond because it's more of a legal question than a operational question, and so that has happened. That has happened many times, I guess, over the last few years. Also, just reviewing number 3, the request for advisory opinion policy. This was adopted in large part based upon the request from PERS that we received, and the commission did not issue an advisory opinion. And this is really done for the purpose of demonstrating that whoever is requesting it has permission to do that, either on behalf of the entity that they are working for or the individual. This also further just articulates that when there is a request for an advisory opinion, the executive director is to consult the chair when it gets there, or when they are determining if they are going to issue an advisory opinion. The other ones that we get to, obviously the commission has an internal code of ethics. The commission reviews this in, I believe it's the beginning of each year. You receive that. I do think that that probably could use some revision as well. And then we have our 5, 6, 7, 8. Those are all related to OMB policies to ensure that we have a low premium for our insurance and that we are mitigating risk when possible. So the other policies that the commission has adopted is a fiscal policy allowing the executive director to expend up to $1,000 of commission funds. That's not regularly occurring, and that he or she has not requested permission from the commission. I know when we adopted this policy, it has been a little bit. There was question about whether $1,000 is too low. At the time, we said let's keep it at $1,000. I personally preferred that so that I knew that there was transparency when we were spending more than $1,000. But since there have been a few instances that I have had to come to the commission and ask permission to buy a piece of furniture or do something in excess of $1,000. So that might be a discussion point about whether that $1,000 amount is appropriate. I have no objection to it, but I know that I believe Cindy had expressed some opinion that that might be too low. The length of officer term policy was updated last month in accordance with allowing the vice chair. It gives them the opportunity to assume the role of the chair instead of that being automatic. I notice now in our policies that that font is smaller. I will update that. At least maybe it looks that way to me. Our computing time policy, this will go into our complaint rules. Is that correct? I didn't want to misstate that. So both our policy, which is policy 11, computing time, and also policy number 12, appeal from a summary dismissal, those were put in to handle or streamline complaint review for the commission, but both of these have since been put into, actually I don't know if 12 has. What was that? We're getting rid of 12, right? So based upon the rules that we will discuss in item number 6, computing time and which is 11, and appeal from summary dismissal, which is 12, both of those will no longer be part of our policy and either be part of our rule or be inapplicable to the process in general. So we'll keep those on the books until we no longer need them, and then we'll have a substitute for those. The commission recently approved and then updated our overtime and compensatory time policies. As we transition to having a new operations administrator, we will discuss this with that team member, but basically just that we will follow the Fair Labor Standards Act and that somebody receives and can receive up to 80 hours of overtime pay, and then also compensatory pay in accordance with OMB's policies on those. Item number 14 outlines the commission's substitution policy when the majority of the commission has a conflict of interest. This is done to manage conflicts of interest or manage conflicts of interest for the executive director or general counsel or any other attorney that's working on a matter. We also did that for the executive director so that there's somebody who can step into the shoes of the executive director. Typically that will go to the general counsel, but if there is also a conflict there, then we will facilitate and find an attorney to serve as acting executive director to manage that conflict. We do have those conflicts arise. It is a small state, so we want to make sure we can manage those. Our records retention policy was adopted last summer, and this is done in accordance with OMB and with this OMB policy and the statute. I guess it's NDIT's policy. We also then added a neutral reviewer policy, which was last fall. Who becomes the neutral reviewer when evaluating conflicts of interest and making sure that we can, again, manage those potential conflicts of interest. And then we get to our annual inventory policy that is pursuant to our auditing standards to make sure that we have comply with what the auditor is asking. Then we get to specifically on that one, we have a asset where we, excuse me, my brain just blanked, that when we maintain our asset inventory, we have our value set to where we start that asset inventory at $50. We did start that quite low. Other agencies have this higher, but we wanted to ensure transparency, so we did. The commission may want to evaluate whether to increase that dollar amount when it comes to our asset inventories. We don't have a lot of assets. Our people are our assets, not things necessarily. So something to consider. And then we adopted just this year, just a few months ago, a bonus structure, a bonus policy for performance bonuses, retention bonuses, and the like. And that was done in accordance with OMB's policies as well. If you remember, Jill Lugas, our HR coordinator, our contact, I know she has a much more official title than that, but she was the one that had talked and explained that particular policy to the commission. So with that, very brief overview of the policies and procedures, I really just wanted to put this on the agenda to see if there is something that the commission wants to adopt, wants us to consider, that they have not heard, that they wanted to hear, or that has come up in discussions outside of the commission, etc.
Anyone have it? Excuse me. Anyone have anything to add or question or change?
No.
Sounds like we're okay.
Okay. All right. Moving on then to our HR update. So I have two large items. I wouldn't say large, notable items on our human resources update that I'm providing to the commission. I was able to and am very excited that we extended an offer of an employment to an individual for our operations administrator position late last week. This individual has accepted the position just this week and will be starting at the beginning of August. Until then and through the transition, Ms. Meyer, our current operations administrator, will be providing temporary assistance and is currently doing that for Logan and I after hours. But also, as we have the transition, Alicia will be coming back and she will be training our new operations administrator. So we are going to have an overlap. We are going to see that on our temporary salary lines, that we are going to be paying for essentially two people for, it might be, at most a month. It's not the best timing with the end of the biennium to have this transition, but also I have very full confidence that we will get our new operations administrator up on all of the information that she needs as soon as possible. So although the individual has accepted employment, he or she is currently notifying their current employer this week. And so once that's done, I will send an email to the commission and introduce our new operations administrator. And I anticipate that they will be here during our August meeting. Any questions on that? Hearing none, I will go to the discussion of temporary employees. So as I noted in our filing update, we have a substantial number of complaints that need to be addressed in a timely fashion, and we have quite a bit of work that needs to get done on those. In the past, yes, we have Logan, and he's very capable of handling those, but his time is certainly stretched. He also, on top of complaint work, our general counsel also provides general counsel services. He is also providing or working on advisory opinions. So his time cannot be completely devoted to complaints. And so in the past, what we have done is we have hired independent outside counsel, and we have done that on, I believe we've done it on 11 complaints. And that is an activity or a practice that we will continue to do. And then those individuals, those independent attorneys, will be appointed as SAGs, Special Assistant Attorney Generals. That's what's happened in the past, and that's what will continue to happen. But we also have those we've done for specific cases when we have either a legal issue or something that requires a lot of time, and it's done really for the purpose of saving Logan's time. One of the options that we're looking at is when we do that with an independent or a contract attorney, the cost of that is significant. It comes out to roughly $300, sometimes more per hour. And that is a significant cost to the commission. We do have operation funds to do that. One of the questions that we are asking, I guess, and really kind of wondering is there an opportunity, or would it make sense logistically and financially to hire somebody, hire an attorney on a temporary basis, meaning as a temp employee, the same way that we have been utilizing Alicia as a temp employee. This would allow an attorney to work for the commission potentially without having to be at a firm or have their own malpractice insurance. It would also potentially save us money. And then we also know that we have attorney time that is dedicated to the commission. So this is something that it would be a good way to utilize some retired or near retirement attorneys. I will also just comment that when the commission goes out and hires attorneys, it is not an easy task to find somebody to represent the commission because of inherent conflicts of interest. And that's not a bad thing. It's just a fact that if a firm has a lobbyist at the firm, they will likely not be representing the Ethics Commission because there may be divergent interests. So that is something that, as we've walked through the process of hiring outside counsel, that is something that has certainly been an obstacle or kind of a roadblock that we've needed to address, just that there's inherent conflicts because of the work that the commission does. So I did reach out to our OMB contact, our OMB fiscal analyst, Stephanie, and talked about this and talked about whether we can essentially use operating dollars that have been designated for professional fees, if we can really use that as for temporary employees. And the question comes down to if they're being used for the same purpose, and they really are. the commission also has a one line item budget, and we can move money as we need. We are one of the few state agencies, I'm sure Stephanie would be able to tell you if there are any others who can do that. Now, we don't do that very often, but when we do, it's done for the purpose of fulfilling a need that was, articulated. So can we make better use of our professional fees by moving that money and using it for the same purpose? So I did speak with Todd Anderson at Risk Management about pursuing this option as well. And this person, whoever this temporary employee would be, or multiple, depending on, would have liability coverage through the state's risk management. And so this is something that I really wanted to get a feel from the commission. If this is something that the commission wants to look at, in order to stay fiscally conservative and use our resources well, but also be able to timely get through complaints and be able to do that, I think the ability to settle will help, but in a timely and meaningful fashion. So I know that was a lot of talking. I feel like I want to hear what the commission thinks, or if they have any questions that they want me to pose to OMB or risk management as we consider this option and how we move forward.
Ron?
I have a question.
Yes, Ron.
If we have this person, would he or she be on kind of a retainer permanently?
So this person, whoever it would be paid just hourly, kind of like what, right now Alicia is working approximately 4 hours a week to keep everything up to date. And so we would work out an hourly rate with this person and pay them a salary based on the hours that they work.
So
it would
what's
not be a retainer.
okay?
But we wouldn't be paying Ron the same amount that we would be to an independent contractor, i.e. a firm, where we're paying their hourly rate.
Okay, like we have been doing with Patricia, right?
Yes. Yep.
Okay.
Any others? Comments or questions? Ideas?
Just a question. I suppose it would depend on who it is, whether they might be working from a home or here. Right?
Yes. Yeah, that's the other thing, is that if we have somebody as a temporary employee, they could work in our office. We could,
Like the intern.
like our intern did. We can get them set up with IT equipment, etc. So it makes it easier for somebody who is potentially interested in that kind of work.
So we would look at a Bismarck person primarily, I suppose, Bismarck or Mandan.
Not necessarily, Ron. I think we'd be open to having somebody work remotely as long as they're accountable for their time and they have good communication with us. It's just an option.
Okay.
I like the idea when we're so short-staffed and want to be timely in our responses to these issues. I think this could surely help us.
I also think it's a very good idea. It provides flexibility to the commission to move complaints when needed and not be used when not needed.
Right.
Just to be clear, this is not an FTE, right? It's not a full-time equivalent. It's not a position, but it is a use of temporary salary funding.
I also like the concept because attorneys who retire will usually not have professional liability insurance. And if they're a temporary employee, they would be covered as a state employee. And so that would vastly expand the potential pool of available people.
Okay, Rebecca, do you kind of get a sense for what the commission is thinking here?
Yep, I want to make sure I'm going to touch base with our HR person. I'll touch base again with Tog to ensure that we comply with everything that we need to for this, for doing this, or exploring this option, and then how we go about getting some attorneys to be helping us out with this setup. So,
Okay, sounds good.
okay. Moving to my next discussion item as part of my executive director report is the discussion of our annual report. So a new section adopted during legislative session 546619 requires the commission to complete and then make public, in other words, post on our website, an annual report. This is something, I'll be honest, it's been on my to-do list probably for the last 9 months. 2 years. Logan says 2 years. This has been something that is a common thing that ethics commissions do. It's a way to be transparent and get information out there. Unfortunately, we just haven't had the time to get around to it. So what better to find the time to get around to it is a statutory requirement to do it. So let's do it. The annual report is due on or before August 29th. So what I'm going to recommend is that the commission call a special meeting before the August 27th meeting to review, discuss, and request any changes so that we can have final approval at the August 27th meeting, and it can be published either on August 27th or the day after. But I want to make sure that the commission is not seeing it for the first time on August 27th, so calling a special meeting at the end of July to walk through it, to review it, make any changes, etc. So we have had the benefit of looking at what other ethics commissions, what their annual reports look like. Some of them are hundreds of pages long. Those likely will not be what we produce, but I think we look at our sister jurisdiction, which is the Ethics Commission that was created at the same time as the North Dakota Ethics Commission. If we look to the New Mexico Ethics Commission's report, you will see what they do. Their most recent one is from 2023, but you can essentially see what their report looks like. They produce their report to the governor and to the legislature, but ours would obviously be for the public or also to the individuals who serve in those capacities. But if you look at the annual report from New Mexico, what this looks like, and then I highlighted for the commission what we are hoping to do in the commission's report. We'll walk through a history of North Dakota Ethics Commission. We'll talk about the commission members, when they are on, what their terms are, and then we'll talk about our operations. They call theirs just operations. We'll call ours operational highlights, and we will focus mostly on complaint operations, advisory opinions, meeting notices, and quasi-judicial and conflicts of interest. So what is going to be an obstacle as we do this first time is that we don't have a case management system in place. So a lot of our information will not be automated. So this will take time to go and grab all of the information, compile it, and then digest it in order to draft a report. So just to keep that in mind, we won't have automated numbers or automated statistics the way we will in the future once we do have a case management system in place. So just a note on that for the commission. We will provide a fiscal report so that we have spending of the commission. I think the first one will go historically, looking back at where the commission started and then what we are at currently. We will talk about education and training, and then we will do legislative, or we can do, if the commission would like, legislative recommendations. So if you look at the statute 546619, there are certain things that the report must include. If we look at what I have highlighted above, that will include all of the musts. It talks about the number of complaints, the status of those complaints, commission actions to resolve the complaints, advisory opinions, and then information regarding education and outreach. All of that will be included in our operational highlights. But what there's also a suggestion for is that the annual report may include recommendations for new laws, new policies that can improve the confidence of North Dakota citizens in their government. So that may part would apply to the legislative recommendations or potentially even commission rule recommendations. So that is a may require. I do have it included. I'm assuming that the commission would like to do that. There's been a few issues that the commission has talked about doing that in the past. So also, if there's anything that the commission wants to be sure that is included in this, I'd love to hear now what you want and if there's anything that needs to be added.
Okay,
Well, I looked at the New Mexico report, Rebecca, and I think it's really a good format to follow. And I like how you've kind of laid it out. And I agree with all the points that we're going to try to make. So
Okay.
I do agree. I think that last piece about recommendations, I think we should do that also because it comes up in our discussions. And a couple of those topics have come up frequently. And so how do we make sure that the other entities or bodies are aware that, hey, we think this is an issue or something that needs to be discussed further?
What attachment is that New Mexico report?
Attachment 3, Ron.
Okay. Thank you.
Yeah, it's a nice looking report.
Yeah. They have some really good graphics, Cindy.
Yeah, yeah. And it was very easy to follow and to understand.
Yep.
A question, will this be done in-house or will it require an expenditure for outside support? And if so, how much money was appropriate?
So I'm going to start with your last question first, Murray,
Okay.
that there was no funds appropriated for this. It will be done at least this first time in-house. And a lot of that comes down to the fact that we don't have automated numbers to be able to hand over to a third party or an external party to do this, right? So we will be doing this in-house the first time. I do think this is going to take quite a bit of my time and the new operations person. Hence why this has been on my list and I have not got to it because it's like biting off a giant thing. In the future, though, I think what the commission should look at is having a report done by an independent third party. Not necessarily as an audit, but just to reflect on what their operations look like. And even to make recommendations as to the commission's operations, which is a little bit different than a report, but could certainly be rolled into one.
And the second question is, if there are legislative recommendations, we need to start thinking about that today, right?
It would be good. I know that I have a few notes on things that the commissioners have brought up in the past.
Because the deadline's only 6 weeks away.
It's quick. Mm-hmm. Yeah, we only have 60 days after the end of the biennium to produce the report. So I have a list of, I don't have it in front of me, I have it on my desk, of recommendations or things that the commission has discussed previously and said there should be a piece of legislation that's outside of the purview of the commission. And there should be something on that. But if there are other legislative recommendations, I would love to get them. I don't think it needs to be a piece of legislation, though, necessarily.
Concepts.
Concepts.
Okay,
Okay.
Or,
yes,
Mr.
go ahead, Murray.
Chair, going back, do we need a motion related to the contract attorneys?
I don't know. Logan or
I don't know.
Rebecca, what do you think?
If you want one, I will give one. If you need one, I will give one.
Do you want one at this point, or do you want to continue to work on it? Or
I,
you have something to
I think I'd
present?
like something more concrete before we do a motion, you know, to hire a particular person or group of people.
Get a job description together or something
Yes.
before.
Okay,
But this can't linger. We want to do it.
No, this
Yeah.
will be, at the next meeting, we'll be
Okay.
talking about this. I just didn't want to be working behind the scenes, working on a way to address our resource issue without the commission being aware of it.
I just want
Right.
to hire somebody soon.
right. I agree. Okay, let's move on on the agenda to the advisory opinion request.
So this is a request from Representative Zach Ista, and it relates to a trip that he was invited to attend to Israel. He's wondering if it presents any lobbyist gift issues because it's funded actually by the Foreign Ministry of Israel. I might have the title wrong, but essentially it's funded by the government of Israel. And they've invited legislators across all 50 states for this trip. So we started working on the opinion. We do have some questions about the objectives of this trip. So he was going to get us in contact with somebody from the Midwest Consulate for Israel, I believe, that initially sent the invitation. He did ask that we work with him to get it out sooner rather than later, so we're going to continue communicating with him. But we've also learned since then that other legislators from North Dakota have been asked to attend this trip as well. There's another trip that relates to a different advisory opinion that is a similar setup. So we anticipate probably having to need a special meeting to get this one out. But we're working on it. We're communicating with the requester, and we'll have more information as we move along.
Well, I think just that
Yeah, it's a tricky issue.
it's one of those issues that there's a lot of context, I guess, that's needed.
Yes.
And it's coming down to when a foreign government is paying to have public officials travel to their country. What's the analysis?
What's the analysis? Because the way the law currently is, there's no distinction between somebody lobbying for a foreign government or lobbying for a foreign government or lobbying for a private entity that's located somewhere in a foreign country. So it really comes down to whether or not they're lobbying, and it's a little unclear what the purpose of this trip is to us at this point. So we're trying to get more information.
Well, I read the memo, the first one from the invitee or inviteer,
Yeah.
the consulate, and I don't know. And again, it's just a highlighted, I guess, section from their invitation that says a study tour for an in-depth exploration of Israel's leadership, society, heritage, and spirit of innovation. So, number one, my mind went to, okay, they have some really good lawyers. Because to me, this seems pretty innocuous. I mean, I know it went specifically to legislators, so it could be perceived as, more than, but just based on the way it's worded, so I don't know. It seems, just yeah, they're going to learn to study and to be informed. So isn't that just then education? But I also appreciate Majority Leader Ista's hesitancy in bringing it to us for questioning. It's like, because, okay, so here you have this elected official who's saying, oh, I don't know, I think it's okay, but is it okay? And I'm going to ask the Ethics Commission.
Right.
Yeah.
That's
So
what we're here for.
What wasn't included in the meeting materials is we have an attachment to that original email we received. And there's a paragraph that says participants will gain firsthand insight into the complexities and opportunities facing Israel today through high-level meetings with Israeli decision makers, site visits to key national and cultural landmarks in Jerusalem and beyond. And then this is the one that we were a little hesitant about, this last piece that says, and direct engagement with experts in political, social, and academic fields. So there's this statement that they're going to be engaging with these individuals, but it's kind of broad. It doesn't say who these people are or what those conversations specifically are. So we're trying to get more information, I think, on that piece. But
Yeah, and that Logan, that piece you just read, that sounds kind of more or way different than the bolded piece we got in the email, where I would have questions, or yeah.
yeah. So we're trying to answer those questions, I guess, to sum it up.
Yeah, what would concern me is with Israel, there's some political concerns I think that we have to be aware of that we might not even consider if it was from another country.
So Ron, that was one of the concerns that we had as Logan was working on the draft, is what precedent is it setting for other countries that may be adversarial to do the same thing, where the politics are different.
Right.
Is that and so I think that was kind of our concern, is let's pick a different country. Does the analysis change, and should that be a factor?
And on the other hand, I think it's important for all public officials in North Dakota to be exposed to what's going on in the world, because North Dakota is increasingly part of a global environment. And the legislators, governors, people traveling on trade missions, all of them need to know what's going on worldwide and the North Dakota's context in that. And basically, it's up to them to make a decision. Should I go to that country if it's an adversary? But I support every opportunity that public officials in this country have an opportunity to know better what's going on outside the boundaries of North Dakota. So here ends my comment.
Well, I think it demonstrates that there's a balance.
Yes.
And that reaching that and making that determination is complex.
But on the other hand, if there's travel and there's travel disclosure rules and it's paid by third parties, that information is available. So it's no secret.
Nope.
Any other thoughts?
I suppose we use the argument, well, if Egypt Egypt's got the same opportunity that Israel had to uh, to make an offer to our legislators. So, so there's no particular bias towards Israel because we would consider the same thing coming from another country doesn't have the same political outlook as Israel does.
But if there's lobbying involved in the trip, the lobbying is not directed to the North Dakota legislature. The lobbying is to try to influence the federal government. And is that the role of the North Dakota Ethics Commission?
And Murray, that's a good question because then it comes down to the definition of lobby.
But it's also specifically for state legislators. That's what this trip is organized around. So we don't know what their objective is.
But even if they heavily lobby state legislators, it's not to influence the North Dakota legislature, it's to influence the federal government or the administration or the Congress. My thinking. So I'm really interested in how this proceeds.
So we are providing this update for the purpose of really saying that this is a time-sensitive issue that we're trying to ensure that we provide appropriate advice on, but also that there are complexities and nuances to this that many individuals, when they're determining whether to go on a trip like this, will have. So thank you for your input. We'll continue to work on it, get more information, but just keep in mind that hopefully we can do a special meeting to confirm or to approve the advisory opinion.
Yep.
Then we can do the draft annual report at the same time.
Okay, that sounds good. Okay, let's move on.
Murray, do you want to give an overview of the?
I was the hearing officer for the hearing on the proposed travel rules earlier this week. And the governor appeared in person, and it was an excellent, what I consider a dialogue. And there was one legislator who appeared online, and there were written submissions. 1, 2.
We now have 3.
3 written submissions. The governor appeared, and he initially discussed his comments about the proposed travel disclosure rule. Did not focus on the first parts of the proposed rule, but focused instead on the penalty provision, and particularly focused on the provision about the potential penalty up to $5,000. And so his comments were transcribed by AI and are in the agenda materials. And I urge you to just review them so that you get a complete understanding of what the governor's comments were. At the same time, he mentioned that he had planned to attend the commission meeting today, but was unable to do that because he had to travel to Washington, D.C. And he took the opportunity to express some concern about advisory opinion 25-01. And again, I recommend that you read the transcript because he didn't focus on the result of the opinion. He focused more on, was this the role of the Ethics Commission to provide an opinion about a statute on campaign finance. And so I just, based on that, I'm recommending in point agenda item 11.5 that we will the commission extend an invitation to Governor Armstrong so that we can have a dialogue about the concerns that he expressed during the hearing.
Sounds good.
Concerning the comment from the legislator, he expressed his concerns, and I think that the proper thing to do is to get back to him and just explain, to address his concerns. And the written material provided prior to the hearing from the Attorney General's office can be summarized by saying that the Attorney General believes that the Ethics Commission does not have any enforcement authority. And I haven't reviewed the others. So that's as the hearing officer, that's my summary report about that hearing. It was very cordial and very helpful. I'm really pleased that the governor appeared in person, and instead of a hearing, it was more of a dialogue.
Thank you for doing that for us, Maury. Okay. Anything else on that item?
Oh, just a comment. The hearing was held this week, and it will be before the commission in August.
It can be, the commission can start discussing it. So the comment period is open until July 28th. So people can still submit comment through the commission's website using the public input tab, or by sending an email to the commission, or calling. We take comments in any form before July 28th. So there's still another 12 days to get comments and receive comments from members of the public or other public officials.
Will it be ready on August 27th?
So I think the commission is going to have to discuss it on August 27th, but all of the comments that we receive, it's going to depend a little bit on how many comments we receive, because the commission will need to respond to those comments. What was that? Consider those comments and then potentially respond or provide information regarding those comments. So it's going to depend.
We have the comments from the Attorney General's office. Will the commission have the comments? When will the commission get all of the comments on July 28th?
On probably the 29th or the 30th or something, yes. Yeah.
Thank you.
The 28th is a Monday, so
Thank
you
you.
have to wait till midnight on the 28th.
The video from the hearing too is on our YouTube page if the other commissioners want to watch it. Instead of reading the AI transcript, you can find it on YouTube.
Yeah, I didn't care for the AI transcript. I'm like, what the heck?
I don't either. They're not very accurate.
It's like, yeah, I mean, it was just really disjointed. All right, and just reinforce for me, Rebecca, then, so that we've got until people have until July 28th to comment on these rules. And then do we normally respond to each set of comments, or do we just consider them in general?
So Cindy, when the commission moves to adopt the rule or take final action on the rule, you have to consider all the comments that have been submitted and create a record that you've considered them in some sort of response. You don't have to directly send a letter to each
Okay.
person to them, but you have to consider what they said
Okay.
in the commission.
So the earliest the commission could adopt them is at the August 27th meeting, but the commission does not have to adopt them at that meeting.
Okay.
Okay.
It sounds like August is going to be busy. And I'm just
Yes.
going to assume right now that this topic or this issue or item is going to probably get pushed back into September. Just my opinion based on I read all the materials and I have some questions or concerns.
On the
That's all.
Cindy, travel disclosure rules.
Yeah.
Okay. We'll be dealing with that later or again at a later date. Let's look at the proposed complaint rules amendments.
So let's go to item number 6 on the agenda, which is the proposed complaint rules amendments or rule amendments. So as we discussed at the last meeting, based on the statutory changes passed by the Legislative Assembly, our general counsel, Carpenter, has drafted amended complaint rules to address the things that were included in the new sections of 5466. This includes time management standards, amended definitions, appeals of summary dismissals, criminal referrals, motions to dismiss, informal resolutions, and issuance of alleged violations, and proceedings for the hearings. What we have done is the notice based on the commission's approval at the last meeting. The notice requesting public comment, so calling for public comment, was published in local newspapers as required over the past 2 weeks. And the rules hearing has been set for September 9th of 2025. And we did this one in the commission's conference room. We didn't do a space. A lot of this is procedural things, so we don't anticipate a ton of comment on this, but that'll also be happening by teams. So you will see a draft, that you have a draft of the, sorry, my papers got out of order here, of the complaint rules, and I believe Logan has it up or can put it up on the screen. We want, yeah, I guess if the commission wants us to go through it again, we can. Can't find the copy.
Mr. Chair, I will have, I plan to propose amendments to the, what you have in front of you is the chapter as amended according to the statutes or the bill that was passed, Senate Bill 2004. And what I would plan to do at the next committee or commission meeting is that I have proposed amendments to that rule on a couple of issues. And one issue is that I believe I'm going to recommend that a complaint be dismissed, is summarily dismissed, if the commission determines that the complaint has been submitted in bad faith. So, for example, if the commission determines that a person is resubmitting complaints on the same issue in an apparent attempt to harass a person, that it can be summarily dismissed, or if a complainant knowingly submits a complaint against a person that's not subject to the commission's jurisdiction in an apparent effort to harass someone, that it be summarily dismissed. And so I will bring that to the commission in a more refined manner. Secondly, if the commission determines that a complainant has filed a complaint in bad faith, I'm going to recommend that the commission be able to assess a penalty against the complainant if it determines the complaint was submitted in bad faith. And so I would like to have a discussion about that at the next meeting. Meanwhile, I will provide a proposed language to be included in a motion and prior to the next meeting so that you can think about it.
Murray, can I ask you,
Yes.
are you thinking along the same lines as like a Rule 11 in the Civil Rules of Procedure, the state rules of procedure?
Which you will now explain to the commission.
So if you, so I'm likening this to a Rule 11 motion, which is a motion that a party makes in a civil proceeding, either in federal court or in state court. This rule is contained both within state civil procedures and federal civil procedures, that somebody has brought basically a baseless or a frivolous complaint, and it is done for the purpose of harassing or just has no factual or legal basis to be brought, but it's being brought nonetheless. And so what can happen in that case is that a party can request that the court impose sanctions pursuant to their motion. And it is very similar to what Murray is proposing. I just want to make sure that that's what he's thinking.
Precisely. So
Okay.
my thinking is that if the commission determines that a complainant is using the commission or using the process as a weaponization concept to harass a public official, that's not the purpose of the commission, to be used in that manner. And that the commission should have a tool to both deter such conduct and, if not deterred, to punish such conduct. So I'm just giving you a heads up that I want to bring it up when the proposed rule is on the commission's agenda for consideration or final action.
Okay, we'll look forward to that.
So do I.
Okay. Anything else on the proposed complaint rules? Hearing none, our next item is tabled. And I think then what we're going to do is take a 10-minute break. We have a lot on the agenda today, so we're going to try to hold our breaks to 10 minutes. So it's 10:10 now. If you can be back here at 10:20. We are on break.
Well, I stopped to visit.
Okay, are we ready to go again?
Ready in Bismarck.
Okay, we'll call the meeting back to order and move to the discussion of settlement guidelines.
Right, so we broached the topic of settlement guidelines at the last meeting, and I'm going to hand it over to our general counsel to walk through a draft policy that we have, or draft settlement guidelines for complaint resolution.
Okay,
Okay, so this coincides with the legislative change that allows the commission itself to settle complaints with respondents directly rather than after informal resolution. So once the complainant is out of the process. Approaching this, we think it's a good idea to have settlement guidelines so the commission can make sure they're fair across all complaints, that we're not proposing much different settlement proposals to different respondents, that it's more even-handed and there's a structure to it. So this is what we came up with. It's kind of a mix of what works for our process, but we also look to Wisconsin. They're the state that really, the only other state that really has settlement guidelines. But then we also went to the Federal Equal Employment Opportunity Commission, the EEOC. They have settlement guidelines as well that they use when they're investigating employment-related issues under federal law. So we use pieces of that to form these guidelines. But this is what it looks like. So I'll run through it. We do have a question for one specific thing, and then everything that's in here as far as monetary penalties, that's a guidepost as a starting point. We'd like the commission to give us some feedback and have discussion on those. But I will go through it, starting here with the beginning. We just lay out why we have the settlement guidelines, that proposed settlements are at the discretion of the commission, that the proposed settlement can happen at any time before that final hearing. Once you're in that final hearing, then it's actually before the commission to make a decision on the merits of the complaint. So then in here we have that the commission can depart from the guidelines if there's aggravating or mitigating circumstances that are present in a specific complaint, and we list those here. So we put the aggravating factors include repeated or willful violations, misrepresentation or lack of cooperation during the commission's review, and holding a position of high influence. Then the mitigating factors, we included self-reporting, prompt corrective action, or a lack of prior ethical violations. So then we included some general guidelines for all complaints that we look to when we're proposing settlements. That, of course, they have to knowingly and voluntarily agree to the settlement terms, otherwise you don't have a settlement. Then it's for the specific complaint. We may have a proposal where there's another issue that might come up in a different complaint, or they're concerned about an issue that could come up in another complaint. So if that's the case, then that has to be specifically spelled out in the settlement agreement. Otherwise, it's just the allegations that are presented in the original complaint. Number 3, I think the commission should have some conversation on as well. This is when the commission's settling complaints, and just the public nature of what the commission does and the work it does, we put in there that settlements with the commission should be open records, meaning the respondent has to waive the confidentiality of the complaint, and that there's a settlement agreement pursuant to that statute, so the commission can report that yes, the commission has worked with this respondent to settle this matter. There was an issue, but it was handled through a settlement agreement and a cooperative respondent. So then when that settlement is issued, it's public, and the public can have knowledge on the commission's activities. Then we put on there that the settlement agreements will be available on the commission's website, that we're not trying to diminish people's rights through these settlement guidelines or through settlements themselves, that the commission shall consider the nature and seriousness of what's alleged. Again, that's similar to the aggravating and mitigating factors. But then there's a lot of, I guess I shouldn't say a lot of, there's a few commission rules that don't have a penalty associated with them. So there we emphasize that the commission will focus on corrective action, public education, and policy or legal reforms. And the policy or legal reforms also ties back to the annual report the commission will be doing now. So maybe there's something that comes up when reviewing a complaint that there's an issue in state law or a lack of state law that addresses an issue. So maybe from the settlement, or part of the settlement is that the commission will propose legal reform to the legislature in the annual report. So we made sure to include that. Number 6, when the commission takes action, I guess it's an unwritten policy, but it's a policy no less, that the commission issues a press release so that the public is informed about its activities. Then we put in there that the issuance of the press release and its content is not going to be up for negotiation when the commission isn't engaging in settlement negotiations. And then we wanted to address number 7 there on your screen. When somebody would breach or say they're going to breach, repudiate the settlement agreement, what the commission will do in that instance. So we'll give them an opportunity to cure it, that we think they're in breach of the agreement. And then if they continue, the complaint could potentially be reopened. And then there's other criteria that the commission can consider, whether it's an aggravating factor in the future. If there's another complaint, publicly note the breach occurred, and or pursue civil enforcement as provided by law, because it is at the end of the day a contract that they are signing with the commission. So then we get into the specific potential ethical violations that can occur, and of course we start with the lobbyist gift prohibition, because that seems to be the big topic of discussion when it comes to commission investigations, other than conflicts of interest as well. But starting there, we need a settlement schedule for how the commission will assess a fee. So the law that authorizes the collection of the fee, it's up to 2 times the value of the gift. But that also doesn't take into account returning the gift if it's possible. So we put that in there, that if it's possible, if it's not a consumable, or if it's not like recreation, that if it's something tangible, they need to return it if they received it. But also then what that fine is for a violation. So we laid it out for 1st, 2nd, and 3rd, starting with just the value of the gift. Rather than 2 times, it goes up from there by a quarter each time. So if you're settling with the commission, you essentially, under this, what we proposed here, you have 3 strikes until that full penalty would take place, where it's actually the 2 times the value of the gift. Weren't sure where to start. We thought that was a reasonable starting point. Happy to answer questions if the commission has ideas or concerns with that, but that's where we ended up when we were drafting this.
Any questions for Logan?
One
Comments?
question. If adopted, would this be in effect a policy?
Yes.
So in the policy handbook.
Yeah, I think we just cross-reference it. We won't put this all in the policy handbook, but
So this would be a policy that we'd want to make sure, it could be included in our policies and procedures, but it's not really an operating procedure or policy. It's more of a public policy. So it's a little bit different, but it absolutely would be up on the website.
Okay.
And so that way it is available for individuals to refer to so that they are aware. It's that gets to that fairness component of complaint resolution.
yeah. So they have a copy before they even engage in discussion with the commission about potential settlement. They'll know what the commission is looking for, but being able to review it online.
We can even send it out.
And we can send it to them too and say, we'll start settlement discussions in X amount of days, but please review this prior. If there's no questions on the lobbyist gift prohibition, I'll move on to the next piece. So throughout chapter 5466 of the Century Code, there's, I believe, 3 sections that specifically direct the commission to assess these monetary penalties. The next one is for lobbying by elected public officials. And this one is an interesting dynamic because the commission is directed to assess a civil penalty of up to $1,000 on any individual who knowingly violates that section. But a knowing violation is also a Class A misdemeanor. So I'll get to this a little later because there's an issue that if they admit to the commission through a settlement, they could potentially be admitting to a criminal violation as well if they're trying to work with us to settle something. So, but another, actually, let's scroll down. At the end here, we have additional guidelines to resolving complaints. So one of them is written acknowledgement of the conduct and the applicable ethical standard, but then we put in an alternative. Alternatively, no contest stipulations or an acknowledgement of the allegation may be accepted at the commission's discretion. So a respondent may say, well, I'm willing to settle this for, let's say, $250 on the first violation, but I don't want to admit to criminal activity in a settlement with the commission. So in that instance, the settlement according to the settlement guidelines, you could say, well, we'll accept a no contest stipulation or just acknowledging that that's the allegation and you're paying the money to settle it, but you're not admitting the full extent of the conduct, that it was a knowing violation and therefore a Class A misdemeanor. So it resolves the issue without potential criminal conduct. But then for this one, with that in mind, again, using the quarter that we applied for the gift prohibition, you start at $250, and then after the third strike, you have the $1,000, the full penalty that applies when you're lobbying as an elected public official or 2 years after. It's the constitutional provision. Any questions on that one? Okay. Then the last one that is in chapter 5466 is the prohibition on lobbyists delivering campaign contributions. This one's a little different, so we wanted to discuss this one with the commission just because of how the statute is. So the statute puts a first knowing violation as a civil violation, a civil ethical violation with the commission with a civil penalty of $500. But unlike the last one where it's a criminal violation at the same time, the second one is when a criminal violation takes place, and that is a Class B misdemeanor. And then the Secretary of State can be directed to revoke the person's lobbyist registration on that second or subsequent violation. So when we looked at this one, we weren't sure if the same scale would work. I think it would, but how we should handle if they're not admitting to the conduct. This is hard to explain, so bear with me. They're not admitting to the conduct. When does the second violation take place? So they could have multiple potential violations before that first knowing violation takes place with the commission. So if we settled it with an acknowledgement, not an admission, an acknowledgement of what the allegation and the complaint is, you won't have that first knowing violation. You won't have the first knowing violation until they admit that it was a knowing violation or the commission proceeds to a final hearing. So that second criminal violation, the second subsequent criminal violation, wouldn't take place potentially until the commission maybe deals with it multiple times or the person admits it. We don't really want to create the appearance that we're trying to work around the statute, because that's not what we're trying to do. We're trying to acknowledge that conduct took place and corrective action is taking place. But if somebody is violating this multiple times, statute should be followed as well, and that should be a Class B misdemeanor. So we didn't really have a proposal there, but to discuss at meeting, because we wanted the commission's input. Did I explain that?
So I think so. I think essentially is the concern becomes when we're drafting settlement guidelines that if we ask for an admission the first time that it happens, then we don't have discretion as to subsequent violations because it goes to a criminal violation and there's no civil penalty that attaches to subsequent violations. So it's kind of the commission only can review it and find an admission one time before it's beyond or outside the commission's authority. So how do we, with the way the statute is set up, how do we encourage settlement on these issues, knowing that as soon as we have an admission or a commission finding that there was a knowing violation, that the next time it happens, it's out of our hands and it goes to the criminal side. And maybe we could do a strict interpretation of the statute and say this is going to be what it is, but that's not really a settlement and that doesn't encourage settlement. So that's why we're trying to get or trying to discuss something in the context of maybe the first time they acknowledge it without an admission. So I think this is one that, because of the unique language of the statute, it makes drafting a settlement guideline more difficult and really comes down to what the commission wants.
Comments?
Mr. Chair, I have a question. So let's say that the state's attorney just doesn't think this is an important issue to prosecute. So there could be 15 knowing violations. And is the Ethics Commission have no authority to proceed?
So if you look at the statute, the language of the statute, it only gives the commission discretion, authority, direction, I think, is to assess a penalty the first time. And then from there, because then it says for a second or subsequent knowing violation of this section, the person is guilty of a Class B misdemeanor. And then the Secretary of State can revoke the lobbyist registration. So there's two things that aren't necessarily addressed in the statute. One, what happens if it's not a knowing violation, but it's a violation? And two, does the commission have some sort of civil penalty that it should be assessing for subsequent violations? The violation has to be. Yeah.
Because I can see a situation in a county that this isn't an important issue, that there would never be a complaint filed.
A criminal complaint.
Criminal complaint. A criminal complaint filed. Or there may not be a criminal complaint filed, and even if a criminal complaint is filed, it may not be prosecuted. So does that mean that the person who is the lobbyist who's doing this can just continually to do it.
I think that's a good question, Murray.
Something that you may want to address in your annual report.
And it might be.
Well,
part
I
of-
think this is Ron. I think that we have issues too. You know, we received the Attorney General's letter regarding our enforcement of or lack of ability to enforce certain criminal penalties. We have to consider that too. You know, we may be able to assess some civil penalties, but I don't think at this, we're going to have some issues in enforcing criminal penalties. We've got to refer those outside of our consideration.
Yes.
Yeah. So Ron, just briefly, I guess the commission's never asserted that it has criminal enforcement power.
No, I understand. Yes, I know.
So in practice with this, I'll give an example for this one. Let's say we receive a complaint that somebody said this lobbyist delivered a campaign contribution, and it's the first one that comes to the commission. So then we can either work through the process and assess that civil penalty of $500 according to the statute, or we can work with them to settle it. Let's say we settle it and don't find, let's say we accept an acknowledgement that the allegation exists, but they're not going to admit that it was a knowing violation. But they'll pay $250 to close it. That's good. We have a settlement there. We fixed an issue. But then we get a second complaint with the same allegation against the same lobbyist. So then we'd have to process it again. Do we assess this? Do we do the same thing and accept a higher fee for them to pay to close it? Or do we proceed and say, no, we need a knowing, we need you to admit that it was knowing, or we'll proceed to a final hearing and find that it's knowing and issue the $500. Let's say that's the case. We go through the whole process and find a knowing violation. Now that's the second allegation made to the commission, but it's the first knowing violation that the commission has found or they've admitted to, one or the other. So now the third time a complaint comes our way, you're looking at the second and subsequent violation where it's a Class B misdemeanor. Well, in that instance, the commission doesn't have really any discretion other than determining whether to refer it. So the question becomes, well, how do we address this issue? The only way we can is to refer it to the state's attorney jurisdiction at that point. You can't assess a higher fee.
There's already been a knowing.
Because there's
Violation.
already been that first knowing violation, even though this is the third one, now it's the second subsequent
Knowing.
violation.
Yeah.
Where it has to be a criminal matter and the commission would need to refer it. Or I guess it's discretionary. You could just say, well, we're not going to do anything with it. But I think in that instance, the commission, it's the third violation before it. I think more likely than not, a referral will take place. So just drafting a settlement schedule with that in mind, is that the way the commission would like to go? That maybe it's a one strike and then we're moving to, you either need to admit or we'll proceed to a final hearing to determine whether you knowingly violated that constitutional provision.
Thoughts? Well, I don't think, I think if it gets that far, where we've got a third offense or a second offense, if there is a frank discussion with the lobbyist who is engaging in that behavior, most of that should be resolved by that time, I would think. But maybe not. Maybe there are some scoff laws that will continue to engage in the behavior. But I suppose with that in mind, we have to anticipate what's going to happen, and we have to be aware that we have to make that referral then.
Ron, I think you're right that most of the time by the third violation or third allegation, I would hope that we could have it cleaned up and that it wouldn't be knowing, right? That they maybe did it by accident. But
Yeah,
we also need to, you know, ensure that we have something in place. There may be an instance too where somebody will just want to admit that they did do a knowing violation, because then the commission can no longer assess a civil penalty. And in order for something to happen, they might be referred, criminally if they're pretty confident they're not going to be. I mean, I certainly wouldn't advise my client of that, but there's some creative ways to address this statute. But coming up with a settlement guideline, because of the unique structure of the statute, makes coming up with a settlement guideline much different than a gifting violation, which is, you can just build on the value of the gift. Where here it comes down to, once there's more than one knowing violation, the commission essentially can't address the issue, but for a criminal referral. So when we come to develop settlement guidelines, should we have them be that, the first, like Logan said, the first one, you're acknowledging the contents of the complaint, but you certainly are not admitting that there was a knowing violation. Is that the standard that we want to set? And how many times do we want to do that, before we hand it over for a criminal referral?
well, I think if we get a third offense, then by then it's time for a criminal referral. I don't think we should go beyond that.
Okay. So Ron, should we draft something that is like the example that Logan used, where the first time somebody would simply acknowledge the contents of the complaint and then pay the penalty or a portion of the penalty, let's say $250, where the second time, if it happens, they would have to admit a knowing violation. And then the third time goes criminal?
Yes, that's what I think.
So it gives us that a little bit more are but staying fairly consistent with the statute. Obviously with the intent of the statute, but for the idea that we are hoping to settle.
Yeah, it works together with the settlement statute.
It would. Any other comments, concerns on that one? It is kind of an odd statute.
Rebecca, you had a requested action, but should we hold off on that?
Ward, I put that in there just as so you had the language for the motion. If we want to wait until next meeting, until Logan drafts that in light of Ron's comments and the discussion, then we can certainly do that.
I think that would be wise. So we actually have a copy of what we're proposing.
Hold on, Ward, 1 second. Oh, do you want to ask him that?
Yes. So, Ward, what I was telling Rebecca is if we take a break, I can draft it and the commission can look at it. But also, if we put it off until the next meeting, then we also have to put off settling a large number of complaints that we think are ready for settlement until the next
Okay.
meeting. So,
Okay.
be approving the rest of it because none of the complaints that we have relate to this provision. So we can
Okay.
start working issues.
How long of a break do you need?
We wouldn't have to do it.
We don't have to do it now, or we can come back to it whenever we take a break, but 10 minutes.
Okay. Let's do that. We'll do that. We'll take a break down the road a little bit and give you a little bit more time.
That sounds good.
Okay.
I'll just finish up here with the last piece.
Okay.
So that's all the ones that have monetary penalties in statute. So then we also have to address, well, we have conflict of interest rules, quasi-judicial rules, and whatever comes before the commission that might not have a monetary penalty. So we included these other 6 criteria for those instances, but they can also work in conjunction with the monetary penalties as well. We wanted to make sure the commission has options when going into settlement discussions. But again, number 1, the written acknowledgement or a no contest or just an acknowledgement of the allegations. A formal public reprimand, identifying the conduct and its ethical implications. When available, if we have training materials available, training to address the underlying ethical issues and a certification that they complete that training. Immediate corrective action or implementation of procedures to avoid ethical violations in the future. Number 5 is a little creative, but undertaking a public service project or ethics initiative to promote ethical awareness. So we think there might be instances where somebody wants to own up to it and acknowledge it and work with the commission to promote that ethical awareness across state government. And then the last one is periodic compliance reported to the commission for a specified period to just make sure that they're following the rules or the law, what have you, that's brought up in the complaint.
Okay. Any comments on that? Okay, what we are going to do then is we're going to move on down the agenda and we will come back to this for action later in the meeting. The next item is an update on the process for appointment of commissioners.
Yep, I'll keep this really short, guys. That just to let you guys know, I attached the news release that went out to solicit applicants to serve on the commission. And to date, I touched base with the governor's office yesterday, and we have roughly 20 individuals. I think it's a little bit more than 20, but estimate about 20 individuals who have applied to serve on the commission. That does include the reappointment of Commissioner Sogsby. He did complete an application. And again, just to let the public who's listening know that applications are being accepted through the governor's office website, the boards and commission website on Governor Armstrong's website. And those applications are being accepted until August 8th of 2025. So we've still got a little bit of time, a little less than 3 weeks. And then after that, the 3 decision makers, the Senate Majority Leader, Senate Minority Leader, and the governor will go through and select individuals.
Any questions on that?
On that, yeah.
Okay. Thanks for that update. We will move to a discussion of media requests. Before I make a statement, do you have any comments you want to make, Rebecca?
On this topic, Ward, I think I'll let you take the
Okay.
But you can let the commission know what we talked about and what was done. But I don't think I have anything.
Okay.
I guess to comment at this time.
Okay. We received a request from the Bismarck Tribune to respond to some questions they had, and I responded as follows. And I'm going to read this actually. It takes a little bit of time, but I think it's important that the public knows what we had to say. In November 2018, voters approved Article 14 of the Constitution, which established the North Dakota Ethics Commission. Section 3 explains the Commission's broad constitutional authority. It says, in order to strengthen the confidence of the people of North Dakota in their government and to support open, ethical, and accountable government, the North Dakota Ethics Commission is hereby established. The Ethics Commission may adopt ethics rules related to transparency, corruption, elections, and lobbying to which any lobbyist, public official, or candidate for public office shall be subject, and may investigate alleged violations of such rules, this article, and related state laws. During the following years, governors and Senate majority and minority leaders, by consensus agreement, have appointed and reappointed members to the 5-member commission. To fulfill its constitutional duties, on May 27, 2025, the commission unanimously adopted the entire report finding Representative Doctor committed 3 ethical violations. The 93-page report is the work product of the entire commission, and the commission stands by the information presented in it as meticulously documented throughout. The commission must always highlight roadblocks to resolving complaints, regardless of who creates them, the office they hold, and the power they wield. It is inevitable that when parties or witnesses do not participate in the commission investigation, their potential contributions will be missing from the report. Further, the commission will never entertain personal attacks directed at individuals it employs, whether as staff or as contractors or individual commissioners. Accordingly, on July 3rd, I was disappointed to receive a copy of a letter filled with personal attacks against our executive director. Such language seeks to undermine the commission's constitutional authority and distract from its work. In a similar context, if an individual is unhappy with the city commission's decision, it is inappropriate to attack the city staff who aid the city commissioner in its decision. The commission understands the nature of its work and create professional and substantive disagreement. We commit to further professional, substantive discussions to build relationships across state government to fulfill the mandate in the North Dakota Constitution. We have felt for some time that we have had a strained relationship with the Attorney General's office, and we need to find a way to work through that. With that in mind, I'm going to propose that we adopt a motion, and I'll read what I think the motion should say, and then we'll look for someone to approve it, and then we can have discussion. A motion to designate commissioner, and we'll appoint one of you, to evaluate the treatment of staff by external parties and take or recommend appropriate action to support a respectful, professional, and productive working environment for commission staff. And I guess at this point I would see, is there anyone who would be willing to do that? Anyone, commissioner? Since we only have 4 serving at this time, we feel we can only have 1 commissioner sign the letter.
I'll do it.
Who was that, Murray?
Ron,
Okay. So that's, if someone would make that motion, and then we'll discuss.
I move to designate Commissioner Ron Goodman to evaluate the treatment of staff by external parties and take or recommend appropriate action to support a respectful, professional, and productive working environment for commission staff, and when appropriate, to also coordinate with Commissioner Cynthia Lindquist.
Okay, is there support for that motion?
I'd support it, but since I'm a subject of it, I don't feel I can.
I'm going to second it.
Okay, Cynthia. Now it's
but
open
it
for
mainly
discussion.
yeah, because I would like to have discussion on this.
Okay, thoughts by any of the commissioners on what's been going on?
Well, I don't want to talk about what's going on. I guess my question is related to the motion. how and why wouldn't this be addressed internally? Because so our staff are state employees, right?
Yes.
And so would we not follow state personnel matters or policies?
I assume
I
we would, but
guess,
I
yeah,
don't know how that all works, to be honest with you.
yeah. And and so, well, I don't know. So maybe our motion designating a commissioner or two to evaluate or to, yeah, to,
So Cindy, I think that that is something that whoever is designated to, for lack of better terms, own this issue, um, needs or can have a conversation and determine if that would be an appropriate action.
okay.
Other thoughts or comments?
In my comment is that I added Commissioner Lindquist because a female is involved.
Okay. I think we're all recognizing this has been so inappropriate. And we need to somehow get back in a working relationship. Anyone else?
Well, it's the point about the working relationship, yes, but it's also, from my perspective, it's the point about professionalism and treatment.
Yeah, for sure.
So,
Okay. Anyone, one more? I don't want to cut anyone else off. Hearing none, we're going to, excuse me, go
Let me
ahead.
ask, procedurally, I don't know that I should try to contact the Attorney General directly. Uh, I'm wondering if I should try to contact, does he have a chief of staff or somebody that I should maybe make a contact with?
Anyone have an answer for Ron?
My suggestion is that you're the appointed commissioner of a constitutional body, and you should communicate directly with the Attorney General.
Okay, I can do that.
Okay. This time we're going to have a roll call vote.
Commissioner Sogsby,
Yes.
Commissioner Lindquist,
yes.
Commissioner Goodman,
Yes,
Acting Chair Kozer.
Yes, motion carries. Thank you, Ron, for willing to serve in this regard.
yep,
Ron,
yes.
I'm going to suggest that I think we've got a liaison to HR, to personnel. Is that young lady we met, I think, when we met in person, is she our contact for state personnel office?
Yes.
Stephanie?
It's Jill Mugas.
Yeah,
Sorry.
Jill.
Oh, okay, Jill.
I think we need some advice or guidance from state personnel office.
Okay, let me get
Yes.
her name. I know it started with a B. Jill Bugas?
Ron,
that how
I'll
you
send
said
it
it?
to you. I'll send
Okay,
it to
send it to me. Okay, good.
Okay, at this time we'll take a 15-minute break this time to give Logan a little more time on his project that he has. And then we'll be back. It is it's 11:05, so we'll be back at 11:20. Okay, see you
All right.
then.